All right, well, let's keep things on time. I see the attendees room has filled up. So again, thank you everyone for being here. My name is Jean-Paul Bevilacqua. I'm a program developer here at OJEN, which is the Ontario Justice Education Network. Thank you for making the time to be here with us for our final webinar of the school year. And boy, do we feel that summer coming along here in Toronto, especially today. So welcome. I'll do a plug too for the Summer Law Institute. I can put a link in the chat. That's our week-long program at the end of August. So we have a fantastic series of panels and events coming up at the end of the summer. We don't want to turn our mind there yet, but it would be, I think, a great session and event to kind of lead you into the school year. We're really excited about the programming. Before we begin, and I welcome our guests, I just want to acknowledge that although we have attendees from all over Ontario, I'm personally coming to you from Toronto, and I want to acknowledge that this land that I'm fortunate to be on today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. And we also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. And, you know, going into each of these sessions, I want to, of course, acknowledge the land, but also I try to think about a link to today's exploration. So without taking too much time, but giving it proper deference and respect, as we think about a presentation about the criminal justice system and criminal law, I think it's important to acknowledge and have in our minds the overrepresentation of Indigenous people in our criminal justice system. This is very well documented, but you know, since we're an organization that is interested in education and youth, let's kind of zero in a little bit in terms of speaking about Indigenous youth overrepresentation in the criminal justice system. You know, the latest statistics we have that while representing 8% of the Canadian population, Indigenous youth accounted for 48% of admissions to custodies. So, you know, if you do that math, that's 9 times the general population when we look at Indigenous youth. So, although Jennifer will be taking us through a presentation that is more broad in nature, I think it's important to have that in mind as we examine these concepts. So now on to our fantastic presenter. Jennifer Brevorka is a partner at Henein Hutchinson, where she maintains a criminal and civil practice. Jennifer has had a varied and diverse career, which was part of the reason I was personally so excited that she was the one to be taking us through this presentation and that she agreed in the first place. She frequently works with executives accused of wrongdoing by employers, former clients, the government, or regulatory bodies. She has litigated in the American and Canadian criminal and civil courts, and also has a past work as a journalist and federal law clerk, which I thought was fascinating, equally fascinating, that she's a certified yoga teacher and that has a deep interest in meditation that I might ask her to expand on later, because in some of my teaching at Osgood, I've started incorporating meditation practice. And while it's fantastic for students' well-being generally, I'm trying to make the, I think, persuasive argument that actually has a role in their practice as well too. So I would love to discuss that a little bit later. And with that, I will pass it over to Jennifer, who we all give a warm virtual welcome to.
Thanks, Jean-Paul. I didn't put this in my bio on the web, but I'm also a reformed teacher. My first job out of college was teaching high school history. Jean-Paul doesn't know this, but in a private school in North Carolina. And then I went on to become a journalist, but I can honestly say that I think my interest in the criminal justice system lies at the intersection of injustice and poverty and sort of the mechanics of the system, which I'd be fascinated if anyone in the audience wants to comment in the chat at all or the Q&A, whether you or your students have had an interaction with the criminal justice system, because from my perspective, as someone who works on the defense side, and I've never worked as a prosecutor, it is a system that once you have brushed up against it, it sort of sucks you in, and it is tough to get untangled. But it is one of the greatest joys of my profession when I'm able to, or our firm is able to successfully sort of close a case and somebody gets to go on with their life. So what I wanted to focus on today is the Youth Criminal Justice Act here in Canada. One of the, I found as a relative newcomer to Canada, one of the really unique aspects of the justice system here in Canada is that it genuinely treats what we call youth offenders dramatically differently than it does adults. And it is because of the Youth Criminal Justice Act that this is done. And I can honestly say, having practiced in both the States and Canada, Canada's system is truly unique. It is truly different and is really catered towards giving sort of a benefit of the doubt, for lack of a better term, to youth offenders, understanding that they are sort of in the development of their brains and their life experience, and holding them to different standards of accountability because of that. So without further ado, and Jean-Paul has put this in the chat, but I invite you to also please feel free to ask any questions. Happy to take them as we go along. I'm going to start with a little brief slideshow of sorts. I had the assistance of an associate here at the firm named Jessica Proskis, who really enjoys working in youth criminal justice matters. And so Jessica helped me put this together. So as I mentioned, the starting point for any criminal prosecution or arrest of a youth, and I think the question you might be asking yourself is, what constitutes a youth? That is someone who falls between the ages of 12 to 18. And in Canada, that is the age during which you are accused of having committed a crime. So, for example, it could be someone who right now is 12 or 13 and they are arrested, and their arrest and prosecution proceeds under the Youth Criminal Justice Act. It also, however, encompasses individuals who are accused of historical crimes. So in Canada, we do not have a statute of limitations on crimes, meaning in comparison, for example, in civil matters, when you go to sue someone, there is generally a statute of limitations that limits when you can, the time under which you have to file a claim. Oh goodness, I thank you for the note. I'm showing the wrong, let me pause the share. I'm showing the wrong presentation.
All good, Jennifer.
All right, is this any better? Do you see the slide itself as opposed to the presenter slide?
No, we still see.
Let's stop. Take two. A second.
Yeah, of course, yeah.
All right, hold on. Let me try this again. How's that?
That's perfect.
All right, great. So because of the unique aspect of the criminal justice system here, where there's no statute of limitation, and there's also been an encouragement, for example, with certain crimes like sex assault, for people to report and prosecute historical sex assault, that you will find occasionally adults who are proceeding under the Youth Criminal Justice Act. And that is because the acts for which they are accused of committing a crime occurred when they were between the ages of 12 to 18. And so they will be prosecuted under the Youth Criminal Justice Act. There are two sort of governing body legislations here that we consider when we're talking about criminal prosecutions in Canada. The first is the Youth Criminal Justice Act, which I've referenced in passing, but it generally governs how youths are to be treated from arrest all the way up through trial, and then if convicted, sentence. It also addresses an aspect that I think a lot of people who don't regularly participate in the criminal justice system sort of gloss over, which is a term that we'll get to eventually, called resolution. Resolution essentially means you pled out or you've reached an agreement with the government as to how your charges should be handled. I think for a lot of people who their brushes with the criminal justice system occur over television, watching trials or hearing about them, it's not understood that the majority of criminal cases do find settlement or resolution through a process of negotiation that involves three parties, really: the defendant or the defense counsel, the Crown, and often the court, which in Canada is also unique, where the court serves as the facilitator to resolving charges. The other legislation that we'll probably talk about today is called the Criminal Code of Canada. And it is the substantive offenses in this code that apply to young people, but then procedurally, they are prosecuted under the youth legislation. What this means in the nitty-gritty is that a young person may be charged with the same offense as an adult. For example, if you have raped someone when you're 13, you are still charged with the same criminal code offense, or let's say assault. You're still charged under Criminal Code Section 265 as you would be if you were 23. What differs, though, is how you are treated during police questioning, during the disclosure and negotiation process, during trial, and most importantly, during sentencing. And that is where, so the two legislations work hand in hand. You really can't have one without the other. I'll move on to the next slide. So I mentioned this early on. Who does the youth criminal justice apply to? It is a person who's older than 12, but less than 18, and the age of the person on the date of the commission of the offense. And we went over that before, so I'll go to the next slide. The Youth Criminal Justice Act was promulgated in 2003, and it is a governing legislation that's based on certain ideas about the youth justice system, with the idea of the collective good and protecting the public. So the idea here is that youth are treated differently, and because we hold young persons accountable through measures proportionate to the seriousness of the offense and the degree of responsibility of the young person. I'll come back to that in a second after I finish the other two. An aspect of the Youth Criminal Justice Act, so any prosecution that involves a young person, one aspect is going to be promoting the rehabilitation and reintegration of the young person into society. So the idea here is not to seek necessarily just justice and or punishment, but rather the idea is really to let the young person understand the severity of the crime or what's been done, and to hold them accountable but to get back to a point where that young person can sort of go back to their life and succeed in society, whether it be going to college, entering the workforce, immigrating to another country.
Jennifer, I'm just jumping here with a question about that. Put simply, or perhaps bluntly, is that not the case for the Criminal Code of Canada and how adults are prosecuted and dealt with? And if not, why not?
It definitely is an aspect, but I think here this concept in sub number 2 is really sort of a how do I say this? It is a principle that is a guiding principle, and one that I think the courts, certainly the judges, stress more so than in an adult conviction. I think under the criminal code, when you're dealing with an adult offender, certainly if they are a first-time offender or they're someone who struggles with a disability, say drug or alcohol abuse, and the crime is a result of that, definitely the code envisions that the idea of resolution or punishment would rehabilitate and reintegrate. But there is also an aspect of accountability that a custodial sentence for an adult may be considered appropriate, whereas I think with a young person, a custodial sentence is often the sort of the last option that the court would want to ever consider.
And when you say custodial, you mean jail or
Sure.
prison?
Yeah,
right?
I mean, so yeah, minor difference. Prison is where people are held to serve sentences upon conviction. Jail is where people sit while they are awaiting trial. So yeah, custodial sentence, or sometimes a halfway house, right? Custodial sentence, you could be sentenced to a halfway house, which is a home where your liberties are restrained to some degree. But you're still allowed to go out to school and come back, or go to work and come back, or you're monitored and things like that. So yeah.
Thank you.
Yeah, no problem. Great question. Um, and so I wanted to get to the last bullet point, which ties into the first bullet point, which is a really this idea that the youth justice system is separate from the adult system because youth have diminished moral blameworthiness and culpability, in part because of the development of their brains, their limited life experience, and their limited experience with society in general. You're seeing right now, if you're monitoring Supreme Court decisions or Ontario Court of Appeal decisions, an interesting trend that to some degree existed in the United States, but on a much smaller level, and really only on significant, items such as the death penalty that, for example, the Supreme Court considered. But here in Canada, you're seeing the defense bar really try to push the idea of the diminished moral blameworthiness of youths who have, for example, limited or no experience with substance abuse, alcohol, drugs, interacting with bullying or responding to that. And the idea is that we want to afford our youth protections and sort of, for lack of a better term, the benefit of being able to learn from this horrible experience, a crime or being charged or engaging in the justice system, because they don't have that same hindsight that we have as adults, or that life experience, or that judgment to sort of stop and pause. So this is a really interesting area if you're studying law or you're talking to young people about law. This idea that the justice system is sort of responding to this concept that young people, their brains aren't fully formed, they don't have the same life experience, and we cannot be holding them to the same accountability when it comes to what we do, for example, with adults who abuse alcohol and then go commit a crime. Let me just move on to the next slide. So extrajudicial measures is also an aspect of the youth criminal justice system. One of the things that the youth criminal justice system tries to impose or impart upon actors in the system is that police and prosecutors have specific authorization that they don't necessarily have with adults, which is to not actually arrest a youth. They can give warnings, they can give cautions, they can call in the youth's parent or guardian and discuss the matter. They could refer them to counseling. They could refer it to a prosecutor, a Crown, for caution. They allow, in this instance, this idea that a young person can understand the consequence of what occurred, but they also have the opportunity to repair relationships in the community. And it allows for community development and sort of this idea of rehabilitation, right? We're going to try to reintegrate them and rehabilitate them rather than arresting them, because once a youth is arrested, they are part of the system, and the system being not only navigating bail and or detention at a jail, but also then the court system. This is a problem in a sense because they are part of a huge machine, the justice system, and now they've got to be involved with lawyers, and often parents are involved and things of that matter. So the Youth Criminal Justice Act is really unique in that it allows the police, it gives them this extreme discretion to try to give young people the benefit of the doubt. So another idea of this sort of benefit of the doubt is an extrajudicial sanctioned. And so this is also an idea that goes beyond an extrajudicial measure rather than just say a conference with police or the Crown. And it's if a young person accepts responsibility for the offense, and what that essentially means is the young person will say, yes, I committed these acts and I had mental state while doing it, and the young person believes the sanction is appropriate, then the Crown, if there's enough evidence to proceed with the prosecution, then this sanction could be engaged upon. And so often that means community service, a prescribed counseling program, or restitution, sometimes in a monetary amount, or for example, a work program. So one of the aspects of the youth criminal justice system, and this is something we talked about earlier with the overlap with the Canadian Criminal Code, is that at the beginning of the process, so let's say the police have decided they're not going to exercise their discretion and engage upon sort of a conference with the youth or their parents, or bring in the Crown to have a conference, but rather they're going to lay a charge. They've got to have reasonable and probable grounds, often called probable cause, to arrest someone. And it's looked at with all the cumulative, or it's supposed to be looked at, the cumulative effect of the evidence known at the time. So what is that evidence? It can be witness statements, it can be videos, it can be evidence taken from phones or from, credit card receipts or phone records. It can be a combination of those. Often, though, what we see, for example, in instances, and I bring this up because our firm handles a large number of these, is in sexual assault, is that what we call a complainant, or the individual upon whom is purporting to say the crime occurred, they will go to police and they will make a statement. They will engage in an interview with police, and that witness statement is videotaped and audio recorded. And from that videotaped statement, the police can decide whether or not there's reasonable and probable grounds to arrest someone for a crime. So when a youth is arrested or charged with a criminal offense, the police, under the Youth Criminal Justice Act, which is different from when they arrest adults, the totality of what I'm going to, list here is the police must advise the youth of the basis for the arrest, their right to remain silent, the fact that everything they say may be used against them in court proceedings, their right to retain counsel, which includes a consultation with a lawyer free of charge, which here in Ontario is referred to as duty counsel, B-U-T-Y counsel. And that's because that lawyer is more or less always on duty and can be called from the police station. And then the right to contact a parent or other adult. And where things get complicated, and I bring this up because of Jean Paul's sort of earlier comments about the disproportionate rate of Indigenous offenders in the system compared to the population rate, but also statistics have shown that persons of color are arrested with more frequency than Caucasians and form a disproportionate, population of those in custody. Where these rights become complicated, as you can imagine, is where a youth is in, say, the foster care system or in a group home, or does not have a good relationship with a parent or other adult, or has a relationship with an adult or parent where that individual is not necessarily responsible. And this is where I think your work as teachers is also important and useful, is in when you're talking to students about these rights, understanding these rights at a very early age, and understanding this idea that when you are held or arrested or in custody, that you have a right to speak with a lawyer, and that conversation is confidential to the point where that lawyer cannot even share the information with your guardian or parents because of the duty of confidentiality. This is a really important tenet to impart to young people. And I think more often than not, in societies, I speak from the perspective and the vantage point of defense counsel, Certainly we're taught at an early age to respect the police and to respect authority to a degree, and understandably, because this is a country built upon rules and laws and a code of conduct that we all agree to. But there are also inalienable rights that we have under the charter, and those rights exist for people who are ages 12 to 18 too. And so it's really important, I think, and almost our patriotic duty, to instill upon young people their ability to understand that they have a right, if they're detained by police, to remain silent and to ask to have an adult present, their parent or another adult, and ask to talk to a lawyer. I'll move on.
Can I ask about that? So, you know, I think, and this really goes for all rights. Knowing about them is one thing and an important piece. The assertion of them is another. So I don't know, in your experience, you have any tips for especially young people to feel empowered enough to, I mean, even speak to a police officer, let alone kind of try to match their authority in a way?
Yeah, great question. What I counsel clients is you don't have a right necessarily to not share your identity with the police. For example, if the police say, you know, what's your name, young man or woman, and you know, where do you live? You generally have to share that. I mean, it's not a basis for arrest, but there's no inalienable right to not share your identity. But there is a way to be respectful, and I think the most respectful way is to let the officer, sir or ma'am, you know, my name is Joe Bob Brown. I live here in Toronto. You know, I'm not comfortable answering questions unless my parent or fill in the blank is here. Can we contact them? And so, you know, I say this because, and I'm pausing, not everything plays out as well as that script goes, but if one maintains sort of an air of respect and tries to just be very as official as possible, it does help. I think where things start to fray is when people, and young people too, try to confront the police or push back on their authority. I can tell you, as a defense lawyer, I have a great deal of admiration for people who serve in law enforcement. And I always refer to them as, you know, officer, sir, ma'am. But I also recognize that if I was ever asked to answer questions that went beyond my name and things like that, I'd ask, you know, I'm happy to talk with you, but I'd like a lawyer present. Do you mind if we wait a bit and get my lawyer here?
Yeah, I think those are really great things to keep in mind, and yeah, I think it's also easier for some people to do that than others, right? I mean, I'm thinking, you know, here we are in Pride Month, and as a member of the LGBTQ community myself, I don't always, first of all, like having police around or feel more secure with their presence. So I think it's important, based on the, you know, for our purposes, as we talk to and our audience talks to a wide variance of people and identities, that there is not kind of like one way that's always going to work in a youth's favor in terms of behaving and interacting with law enforcement.
Yeah, I mean, it's really easy for me to say, as a white woman who's got a law degree, right? Who's in, you know, my middle age, to say this is how you do it. I understand that if I was a, you know, 16-year-old Indigenous person who was living in foster care, I'd have different life experience. But I think the first and foremost is, one, always, you know, I always in part try to treat the police with the respect, because they are performing a job and they're performing a duty. And the second is, you know, answer the question and then just simply ask for a lawyer, and you can maintain that until the lawyer arrives, or in this case, the parent or adult. And the other thing I think to impart upon young people is that under the Youth Criminal Justice Act, it does require notice to a parent, either orally or in writing, upon a young person's arrest or detention as soon as possible. So parent is a broad term. It's used as any person who's under a legal duty to provide for the young person, or any person who has in fact, in law or fact, the custody or control of a young person. So this could include biological parents, adoptive parents, foster parents, legal guardians, or even step parents, or a representative of children's aid society. Generally, after arrest, the next step that comes in the process, whether this be for young persons or adults, is bail. And so, depending on the offense, the police will determine whether or not to release a young person with or without condition, or detain them in custody pending their trial. And under the Youth Criminal Justice Act, a court may decide to detain a youth under several criteria. One, the youth is charged with a serious offense. So this is an offense for which an adult would be liable to 5 years or more in custody. Generally, this is an offense that involves an act of violence against another, that may involve a weapon or involve serious injury to another, and has a pattern, and that youth also has a pattern of outstanding charges or finding of guilt. And the judge is also satisfied that the young person will not appear in court when required, or that detention is necessary for the protection or safety of the public, or that detention is necessary to maintain confidence in the administration of justice in regard to all the judges in bail have an enormous amount of discretion. And this is also an aspect of the process where I think adults in youth's lives can play a huge role. So at a bail hearing, a lawyer for the detained, for the accused, can put forth evidence to try to demonstrate that the young person will appear in court when required, or that detention is unnecessary for the protection of the safety of the public, or that reoffending is unlikely. And you may ask, well, how do you do this? Often in my practice, it's been that people from the community who know the young person well, a member of their church, a pastor, a teacher, neighbors, if the youth is employed, their employer, or people that work with them, actually come to court and can testify or can submit written evidence. Also, the parents can comment on, or others that work, if this is a young person who's been suffering from mental health illness and has a counselor that they're working with, that counselor can comment about the work they're doing and why they think that young person will appear in court when required. So I think, though, one thing to import when you're talking to young people about the system is nothing happens quickly. And I think that's a misconception from television, that often people are arrested and the next thing you know, you're standing in court and you're before a judge and they're determining bail. Often what happens with a fairly innocuous charge where there's not a serious offense is, what I've seen before is the police will call the parent, tell the parent that their son or daughter is going to be arrested, ask them to bring them down to the station, meet with the young person while the parent is present, answer, arrest them on video camera, and let them go with the parent agreeing to, basically, for lack of a better term, make sure they appear for all court appearances and that they will not flee. I would say that occurs, when they're not serious offenses and when a parent is clearly present and involved. Where things get trickier is when perhaps a youth has had repeat offenses, is in a group home, or is not in children's aid society, or doesn't have parents present. And that is, again, I think, goes to Jean-Paul's point about the criminal justice system and the disproportionate effect it can have on not only people of color and indigenous people, but also those in a lower socioeconomic sort of background where a stable home environment isn't always there. And there, I think, as teachers, it's important to point out to young folks that reaching out to people in authority, like your teachers or your principals, for help with this And in regards to bail, that can be part of the solution too. But often a bail hearing can take a few days to occur before these conditions are decided. Or you may have an initial bail hearing and they decide to detain the young person, and then it's going to take a few days or even a week for defense counsel to assemble evidence and take another run at it, for lack of a better term, to get the young person released. I'm just seeing a comment. Yeah, go ahead, John Paul. I'm just, yeah.
So I'll read it out for the audience, and it's my apologies if I mispronounce it, but Shua, and they are from, I assume, the OCL, which is the Office of the Children's Lawyer for our audience, and they are asking, I work with older youth and child welfare system. Often I find that CASs, so Children's Aid Societies, are unable or unwilling to offer placement options that would allow for a release on bail. So they're wondering, Jennifer, do you have any insights or thoughts on what to do in those situations?
Yeah, and I hate to engage more chat, but I'm not sure when they're unable or unwilling to offer placement options that allow for release on bail. Does that mean they're unwilling or unable to offer options like to a home, to a group home, or a stable address?
I'm guessing that that would be satisfactory to a court to feel confident in releasing the youth on bail.
Foster home or group home. Yeah, and unfortunately, that is a really tough situation. I don't, because it's going to be on a case by case basis, right? Because some of it is going to be whether they CAF thinks that return of that youth to a foster home or group home is going to be safe for the rest of the individuals there. I think in those instances, what you want to try to do is help that youth accumulate a file to take another run at a bail hearing. And it's tough because they're not only are they detained, but they're a young person and they're subject to CAS, where others who have interacted with them, counselors, teachers, fellow students who are older, can comment on that they don't perceive this person as a danger to them, or as a danger to others, or as disruptive to the group or foster home situation. The idea is that, you know, and some of this is, I'm not clear on the basis that CAS would be unwilling to offer the placement options, but the other aspect I guess I would ask CAS would be sort of like, when you're putting forth that they're not offering placement options, why is this not a possibility? And can you explain in writing why this isn't? Because I find often, sometimes when I push back and I ask, well, could I see that policy or procedure that prevents you from doing X, Y, Z? It's not really, it doesn't exist, or maybe they put it in writing, and that way you can find a workaround.
So Shua is actually, and please correct my pronunciation if I'm going off, actually has their hand raised, so I'm just going to allow them to talk about it.
Yeah, please.
Okay, please go ahead. You're able to talk now.
Thanks a lot. This is a really great presentation, by the way. And I don't want to sort of monopolize it with this sub issue, but what I find with CAS is, especially, you know, I mean, post-pandemic, there's been real attrition in terms of foster parents and placements generally. And so what I'm finding is that CASers are saying, we got nothing. And this sort of, well, we don't have anything to offer. I mean, you know, in my perfect world, they would work more actively with external organizations that have more expertise in these areas to develop specialized placements, but it's far from that. And I'm just wondering, it's just frustrating because they do end up sitting in custody because CSs are saying we got nothing. And what you said earlier about actually getting information from other people is helpful. I'm wondering, like, do you bring them to the bail hearing? Do you get affidavits? Like, what's the way to get that input? A letter?
So sometimes it's a letter. I had one recently where I got an employer to write a letter. This is not for a young person, it's for an adult, but that other person was overseas and an employer wrote a letter. So, you know, putting it on letterhead, putting, you know, the number that you can be reached at, because you're often doing this. It sounds like you have a lot of experience with this. So, or, you know, experience with this. You're doing this really quickly, right? Because the bail hearing is about maybe a day or 2 days, the initial one after arrest. And so a letter is great. If you can get an affidavit, that's super. I've also, I mean, literally pulled people into the courtroom, and certainly in Zoom court proceedings. And I mean, it's a really sort of like rough and tumble. This is our witness. And, you know, Your Honor, this is what I'd like to ask them about. So that's kind of on that regard.
Thanks, that's really helpful. Sorry, my,
Okay,
my
yeah, no,
6-year-old's in the background.
no. And I think to your question, I think, you know, the only pushback I could see with CAS is to ask them, well, okay, who did you contact, right? Could I have a list of who you've contacted? Because in the event you've not considered somebody, I just want to make sure maybe I could reach out to them and see if they have room. Maybe we could give them a call. I'd also be curious. I mean, I know it'd be curious to see what the CAS rules and procedures are as far as once a youth is arrested and needs foster home placement, if they're required to, you know, make a number of calls, or I'd just be interested in the process they're supposed to be following.
That's a really interesting question. I'm not sure that there is one that is established or consistently applied, but it's certainly a question that I'll ask at my end.
Yeah, okay, well, good luck.
Thanks.
Thanks. Okay. So that's bail, and as I mentioned, sometimes when young people are detained, it seems like time sort of slows down, and you're really scrambling in the initial few days to that bail hearing, and often a lower level judge may not feel comfortable releasing somebody, so you may also have to have a second bail hearing or take another run at it with more evidence. So that's bail. Disclosure. This is a term in the civil system, we call it discovery. But here in Canada, under the criminal code, a prosecutor must release all evidence in its possession and control to the young person or their lawyer that could be relevant. So it's a really broad umbrella. It's not just it is relevant, it could be. And it has no bearing on whether it's going to be used at trial or not, or whether or not a witness is reliable or worthwhile. The difference here, though, is, and I'll get to what disclosure maintains, is these are the materials that are in the police's possession, or the Crown's possession, custody, and control. There's a nuance here, though. It doesn't mean the police have a duty to go out and get this evidence. For example, let's say a crime occurred on a street corner where we know there's a traffic camera and we know the intersection is filmed 24/7 because we see it on CCTV when they're showing us the rush hour traffic. But the police don't have this and they've not produced it, and we've asked for it several times. You would have to go through a separate process in the court system, the lawyer would, to seek that evidence from a third party. You cannot require that the police go get the evidence. So there's where this becomes of interest, as I'm sure you all know from being teachers, is what is it we all are, I'm turning around to pick up one of mine, carrying around 24/7, a phone, right? I mean, this is literally a computer that is attached to our hips from the minute we wake up until the minute we go to bed. I have seen countless cases, and I'm sure prosecutors or other defense counsel have too, where witnesses talk about texting, calling, Snapchatting, Instagramming, whatever. And the police may very well have an interview of that person, but not that person's material from the phone because they've never collected it. So they have no duty to necessarily collect that, but there is a process in the court system, which you can undertake also, where their lawyer can make an application to get those records from the complainant or witness. It is a much higher bar, though, than this disclosure bar. You have to go through a two-step process, and you have to demonstrate relevance to the charges or the defense. So this term disclosure that we've thrown out, what does that mean? It pretty much means anything. It means the police's notes, both handwritten and typed. It means their emails back and forth with, okay, I'll get to this in just a second. It means emails back and forth, for example, with the complainant or their parents. It means photographs taken. It means things, for example, when a witness comes to be interviewed and they sit down with the police and they say, yes, I've created this timeline to help me remember things, and I'm going to read to you from the timeline. If the police collected the timeline or they've relied on it during the interview, that would be something the police have had to hand over. So one of the questions asked in the chat was, are there timelines associated with disclosure? How long do prosecutors have to turn over the evidence to defense? So this is a great question. There is no strict timeline, but there is a timeline. Under the charter, we have a right known as an 11B right. It is essentially a right to a speedy trial. And what the Supreme Court of Canada has said is that that more or less means from charge or indictment until trial, the Crown has about 18 months, give or take. Sometimes it's a little less, depending on certain factors. Sometimes it could be more if there's delay from defense counsel or other unexcused delay, a natural disaster, the initial COVID delay, things like that. So disclosure generally here in Ontario is supposed to be provided, some form of it, before the first appearance. So generally what police or the Crown will produce before a first court appearance, which is anywhere from about 4 to 6 weeks after initial arrest, is the charging instrument, the basics of the arrest and things like that. Sometimes note, surveillance video, the witness statement, interview of the complainant can come months later. This charter right, this 18 months is the window where at the end of 18 months, if nothing is produced, the individual has a right to bring a motion to essentially get, for lack of a better term, the charges dismissed because of delay. And essentially the Crown will have to oppose the motion or concede the motion and a court will decide. So more or less the timeline is you've got to produce it pretty quickly. I would say within a year, because you have to understand from the defense perspective, I can't make as a lawyer, I cannot advise a counsel or a client, excuse me, on whether to accept a plea, to stand trial, to try to negotiate down, to try to ask for a conditional withdrawal, which is where the charges are withdrawn on, say, the condition of counseling or something like that. I can't counsel a client on that until I see what the evidence is that the Crown has against them. And only when I counsel them can I then go talk to the Crown about a conference and set trial dates. So I would say that if the Crown has not started producing disclosure within a year of arrest, there are some issues there, and you're likely to win what's called an 11B motion. And I'm happy to share the slides with Jean-Paul, and he can then share the slides with the group.
Thanks, Jennifer. I didn't want to assume anything, but so just for the participants' knowledge, and just as I'm saying this, Jennifer, I feel like the chat has left an imprint on your slide. So if you maybe just there you go. Okay. The recording will certainly be circulated. Now that Jennifer has kindly offered the slides, they will be circulated as well post webinar.
Super. And I took the chat off. Okay.
Thank you.
So I talked about a couple of these things here. First appearance. This is not a trial date. It is your initial appearance, the documentation given them by police, and that's when you tell the court, you essentially stand up as an accused, whether you're an adult or a youth, and you say, I'm not guilty, I'm hiring a lawyer, I've requested disclosure, and this is when, these are some other updates. Generally, especially for a youth proceeding, a court will want to know about whether there's been disclosure received, whether there's been an ability to schedule a meeting with the Crown, or other scheduling matters. I will say this, here in Ontario and certainly in the Toronto region, I can't speak to further out, but there is an incredible backlog of criminal cases because of the pandemic. And so what this means is that Crowns are very overworked. They have a lot of cases. And while you may get disclosure relatively quickly, scheduling a meeting with a Crown prosecutor is a tougher thing to do. And they also have a lot more cases to deal with now because of the backlog and the pause that occurred during 2020. So one really important thing to note about Youth Criminal Justice Act is that it conceals the identity of young persons during the criminal justice process. So publication means that it is prohibited to make the identity of the young person known through any public means. Now, what's interesting about this is that in Canada, we are fortunate enough that judicial decisions are when they're written up, whether it be for a legal application or a motion, they're housed in a free website. Perhaps some of you have gone there, called Canley, CANLII, and it is where you can read case law for free. The difference with youth cases is when there are decisions from youth criminal justice acts that are put up there, they are identified by initials, both generally the complainant and the accused. And there is also a big publication ban on this that says that publication of this is considered a crime and is not permitted. I would say this aspect of a youth proceeding is taken incredibly seriously. And it also changes, I think, the proceedings themselves. Once you get out of sort of the initial first proceeding and the check-ins with the court, which happen about every 4 to 6 weeks, let's say you're going to trial. Often, at least in the Zoom era, I've tried one case over Zoom to the bench involving a youth accused. Because of the publication ban and because of the concern about the identity of the complainant and the accused, at the start of court, although we have an open court principle, the court took great pains every day to ask who was attending and how were they connected to the case, and to understand, their role in the case, if any at all. What this is, it's a little different though than in an adult proceeding where the public just freely shows up and observes. So courts, while they understand they have to allow public access, so the public, journalists, teachers, parents, friends, neighbors can sit in on a youth proceeding and observe it, but they cannot make a publication about the young person's identity or information that would allow them to be identified. One of the things I talked about earlier is trial and resolution. So resolution is our lawyer way of saying, essentially entering a plea. It's a little broader though, and I like the use of the term here in Canada, because in the States, we generally talk about entering a plea. But here, resolution is it's a great concept. Sometimes it involves a plea, it could involve sanctions, it can involve work release, it can involve what's referred to as a peace bond, which is where it basically prohibits contact with the complainant for a prolonged period. It may also require, for example, I mentioned a conditional discharge. So someone has to attend, say, anger management, or drug and alcohol counseling, or another aspect of that. And then the charge would be withdrawn. This is a much speedier way to bring about a close to the charges than necessarily standing trial. I think one aspect I didn't put up here, but I should have included in the slide, is an accused's right to go to trial is a decision that they alone get to make in their case. So there are certain aspects, and this is true for young people also. Their parents don't get to decide this, the lawyer doesn't get to decide it, the court doesn't get to decide it. They get to decide whether they will resolve the matter in negotiations with the Crown or whether they go to trial. This is another important aspect about the criminal justice system, is that as a lawyer, I give my clients advice and counsel, and they either accept it or reject it, and they give me back instructions. And one of the instructions is that the accused will instruct counsel whether or not they want to proceed to trial or resolution. Another aspect is whether or not the accused wants to testify at trial, right? So this is a decision that only the accused gets to make. I can advise them what I think and what my legal advice is, and they can either accept that advice or they can reject it, and they will give me instructions to that. I wanted to spend a bit of time on this because this is really where the Youth Criminal Justice Act, I think bears the biggest difference with the adult system. is that whether you go to trial or you've entered a guilty plea, there is a separate process known as sentencing. It is separate and apart from the guilt and innocence phase. And under the Youth Criminal Justice Act, the court considers how a youth should be sentenced. The Crown will, so let's say we reach resolution with the Crown, and let's say we agree to a plea, the parties agree to a plea for a crime, assault, simple assault. The Crown will take a position on sentencing, and the defense can either accept or reject or put forth its own position on sentencing. Sometimes the Crown and the defense agree. Other times, the Crown may seek a sentence that the defense thinks is inappropriate, and then we make submissions to the court, which is essentially we argue our position. And so the court must, in deciding a sentence, craft one that's proportionate to the seriousness of the offense and the degree of responsibility. It's got to be similar or proportionate to other youth sentences in similar cases. So one aspect of this would be when lawyers make their arguments to the court, they will point to case law, this idea of Hanley that I talked about, where cases are out there, where sentences are published or they're aware of other sentences. And they can say, well, you know, this judge in Toronto has sentenced X number of offenders to this type of sentence. Or maybe defense counsel is aware that the judge there before has sentenced offenders to a similar type of offense, and they can refer to that. This next bullet is really important. The sentence is going to be the least restrictive alternative and one that's most likely to rehabilitate and reintegrate the young person. And I think this goes to Jean-Paul's question before about the difference with adult sentences. While certainly the Canadian Criminal Code aims to rehabilitate people, that's an aspect of punishment, it's not going to put the emphasis on that, the sentence be the least restrictive alternative. And then also the last point I'll point here is that any sentence given is not permitted to be any more severe than what an adult would receive for the same offense. And these are the various options. So you can see that custody and supervision sentences are sort of the last resort when it comes to youth offenders. What is more often than not is that the court is going to, what I've talked about before, this idea of an absolute, let me go back, or conditional discharge, that there's conditions that maybe the youth has to go get a job and pay restitution, or maybe they have to engage in community service, or maybe they have to enter counseling. And also before it's discharged. And also there's also community-based sentences. So custody, when it comes to youth, is really a sentence of last resort. And then custodial sentences are really for violent offenders to protect society and serious repeat offenders. Again, serious here generally means inflicting harm upon others. And I'm going through the last slide, I think, because we're coming up to the end and I don't want to go over. I know we're all busy. Youth records. Under the Youth Criminal Justice Act, youth records are sealed, and there are very limited access to these records. If you are charged again as a youth within a period of access, that youth record may be disclosed for a court purpose. I think it's important to note here that I've not had experience about this myself, but I've talked to other immigration attorneys who have, that generally speaking, youth records are sealed and are not accessible by law enforcement after a period of access expires. However, when it comes to immigrating, if someone intends to go and live in the United States indefinitely, let's say you're Canadian and you want to eventually go work in Hollywood and be a movie star, and you know you're gonna, you're 17 and your dream is to star in the hit TV show, and you're gonna try to get a green card and immigrate to the United States. There is a possibility, and I've spoken to immigration attorneys who have seen this happen, that immigration officials in the US can and will access these records. It is not an absolute. Certainly within Canada, these records after the access period are sealed, but this is not a sealing that is, in a lockbox that nobody else can ever accessed. I mean, there are means, and the two countries do share arrest records quite freely with the idea or eye towards border safety. And this goes to the next slide. Collateral consequences. So this is something I want to stress upon. Often when someone is arrested, the initial thought goes to the arrest and being in the system and all of this. But there are other consequences to arrest, and one of which is immigration. We often counsel clients while they're under arrest, awaiting resolution or trial, not to cross into the United States, because while that arrest record is open, it's not sealed, the two countries do share arrest records quite freely. Employment, during a certain period, depending on the type of employment. For example, if you're going to try to work with young people, if you're a youth who wants to work at a daycare, let's say, there could be a need to pull a record check, which could be open during that period. And then there may also be education or licensing consequences. For example, you could be asked, have you ever been arrested? The answer to that has to be yes, because you were. Now, your record is sealed, but the question is more open-ended than, were you convicted or things like that. In Canada, generally questions that pertain to jobs tend to be more based on conviction rather than arrest. So that's less of a problem. I want to look at, cognizant of our time, Jean-Paul, and I see chats. Yeah.
So let me ask the two remaining questions just to be mindful of time. So the first is, can you speak about IRCS? And for our audience, what I assume the question asker is asking about is the intensive rehabilitative custody and supervision program, which is connected to youth justice. And the second question from Bree is, can you briefly mention how a youth is sentenced as an adult? What would a max sentence for a first-degree murder conviction by an adult be? Students ask Bree this question and they're not sure.
Okay. Unfortunately, I cannot speak about IRCS because I don't have personal experience about it. So and I've not encountered it in my practice. So I don't really have a lot to add to that other than passing book knowledge. So I'm sorry about that. But the second question for Bree is, Bree, I'm gonna send Jean-Paul a written answer for this that you could share with students. And here's why. Again, excuse me, the max sentence for a first-degree murder is going to depend. Sentencing is a holistic process that really looks at an offender as a whole. It looks at the history of the person, their contributions to society, the type of crime, like how it was committed, the modes, whether, I'm trying to think, the premeditation and the extent of that involved, similar sentences for crimes of a similar nature. And I understand first-degree murder is certainly a crime that's statutorily defined, but there are different types of first-degree murder, right? I remember as a police reporter, I had a case where parents had literally tortured their children to death. That's a different first-degree murder than premeditating, something like that. So let me find out if I could, Bree, and I'll send it to Jean-Paul, the max penalty. I'll look that up in the code and sort of some of the factors. But it's an answer I think that kids hate to hear, which is it depends. And that's because whether you're a youth or adult, sentencing, and this goes back to ancient Roman times, sentencing really looks at the person as a whole. And that's where a person's history and sort of their contributions to society come into play, and a court can take that as a mitigating factor. It's also why often with first-degree murders, you will, as a defense counsel, try to have essentially what's called mitigating report or a mitigation expert. For example, if someone's had a really horrific childhood, right, and has been abused and was in foster care, and those were all factors you'd want to point to when sentencing comes, so that instead of the max 30, let's say 30 years, the court would sentence them to a lower sentence. So I will send that to Jean-Paul so you can answer the students. Jean-Paul, I'm going to take down the share because I see we're over time, and I don't want to keep the group.
Yeah, I mean, I can tell they're totally engaged, but I want to respect their time as well, and yours too, Jennifer. Thank you so much. I mean, these presentations are always super interesting. This one is also super useful, and I think we'll have a real impact and an empowering one on the audience and those that they educate. So I'm super thankful for that, Jennifer, and to your associate Jessica Proskis for assisting with this. We at OJEN rely on the generosity of practitioners and professionals and experts in order to disseminate and share this knowledge. So I'm deeply appreciative. And a virtual round of applause for Jennifer. Thank you.
Thanks, and thanks to your attendees for all that they do in being teachers. I'm so appreciative of their contributions to society. So thanks.
Yeah, you can tell that they care through many ways, but the engagement throughout the presentation was certainly one of them. Thanks, everyone.
All right, take care.